everyone. Welcome to IPWatchdog Unleashed, where each week we journey into the world of intellectual property to discuss the laws, news, policy, and politics of innovation, technology, and creativity. With analysis and commentary from industry thought leaders and newsmakers from around the world, IPWatchdog Unleashed is hosted by world-renowned patent attorney and the founder of IPWatchdog.com, Quinn, who has twice been named one of the most influential people in the intellectual property community and recognized numerous times as one of the top IP strategists in the world. Take it away, Gene.
Thanks, Renee, and welcome everybody to this week's edition of IPWatchdog Unleashed. Today we're going to have a conversation about the PTAB. I have PTAB on the brain because we spent the last day and a half with our annual PTAB program, and there just hasn't been enough said about the PTAB yet, I suppose. Being a little bit facetious there, of course, but what we've been doing over the last day and a half is really diving deep into the PTAB. We've had great interaction, wonderful speakers, and we had a great event. We had 750 people register for the program, so there's obviously a lot of interest in the topic. We hit a nerve, and we're going to have that conversation continue today with maybe a little bit of a different slant during our time here during this podcast to talk about ways to maybe make the PTAB better, IPR better. And I've asked Matt Johnson to join me. Matt is the co-chair of the PTAB Practice Group at Jones Day. He was one of our speakers over the last day and a half. And I guess the way to describe Matt is as a PTAB lifer. He's been doing this since the very beginning. Matt, great to have you here with us. Thanks for joining us today.
Yeah, thanks, Gene. Super great event the last couple. Appreciate you having me on here this afternoon. I was fortunate enough to get in at the PTAB ground level back in September 2012. Before then, my practice was largely patent prosecution, a bit of reexamination, inter-parties reexamination, and the fun that was there. But was fortunate enough to get staffed on some of those very early covered business method challenges between battles between Liberty Mutual and Progressive Insurance, and got to be there right from day one. And really loved it. Loved the PTAB off the bat, regardless of what you might think of some of the results. Some of the theory in the AIA, did come true. It was a battle that was more on the merits. You weren't getting into the weeds of discovery and the passive aggressive letter writing back and forth. The petitioner put on their case based on their prior art. The patent owner, for the most part, was arguing back about the patentability of their claims. And you were in front of well-educated judges who knew the technology, who understood obviousness, and you got to argue about what mattered, or it seemed like you were arguing more about what mattered at the PTAB than maybe in some other forums. So I fell in love with it right off the bat. Decided to become firm PTAB nerd and learned as much about it as I could. Whenever a question would come up, I would run off and do the research, write up an email about what the case law was, and circulated it. And the questions just kept on coming back to me the more and more I did that, and was fortunate enough to find a niche that also became very popular, way more popular than I think even the patent office thought it would be back in 2011. So it's really been a great run and a fun ride to be on.
So there's a lot there for us to dig into, and I like to start these conversations this way, asking people how they got into this area, because you never really know what's going to come up. And one of the things I think I heard you say is that you were having fun. Did you actually use that word, having fun, with inter-parties reexamination? I'm not sure I've ever heard anybody describe it in quite that way.
Yeah, I may have been being facetious. I mean, the inter-parties reexamination was definitely, it was a bit of a circus.
Calling it a circus is probably being generous, I suppose. It was really one-of-a-kind type proceeding, I suppose. But you did manage to say that with a straight face, which I do admire. But the one thing, and I'm just picking some fun at you here, but the one thing that did come up in what you were talking about, at least what I heard you say, I think I heard you say, was something that I hadn't really thought before. We're patent nerds. We're into science. We're into the patent rules. We're into process. We want to roll up our sleeves and talk about innovation and distinguish innovation. And sometimes litigation gets a little contentious. Sometimes there's unnecessary contention, and people seem to thrive on that at times. And that can be an awful lot for us in the patent community to accept. And we would probably much rather be talking about the science and innovation, whereas if you're doing PTAB, that's precisely what you're able to do.
So it's so true. I get to ride along on some of the trial court litigation, and just the letter writing, the Friday night letters about discovery disputes. There's a real skill in, one, being able to write those, but two, being able to just stomach those and not have them stress you out and ruin your weekend when someone's saying how badly you're behaving. So much of the time it's harassing, and it's not about what really matters at the end of the day. And that's why the PTAB's always been so cool to me. It's, it's obviousness, it's the invention, it's the prior art. Counsel for both sides, the prior art, the experts, and the judges all know what's going on. In theory, you're battling it out about what really matters, and that's what's always been so attractive to me about it.
So I started out my career doing litigation, and I think it changes your personality, or at least it did so with me. And it seems like there are just so many litigators that are out there that they're trying to prove that they're the smartest person in the room, and they're trying to make your life miserable. And it seems to me that when they think they're accomplishing both of those goals simultaneously, making your life miserable, making themselves seem smarter than what they probably really are, they get energized by it. And I guess if I'm honest, I'd have to admit that I would get energized going the other direction, because if somebody was going to act like that towards me, I'd be like, okay, pal, strap in, because I'm going to come after you. I'm going to be ready for you. And that just didn't strike me as a long-term way to practice law. Didn't think it was going to be a wholesome lifestyle that I wanted. It just changed me too much. Although I will admit that when I'm involved in disputes anymore, I probably do get a little too energized, a little bit too much.
That's one thing I found with the PTAB bar. It's and a lot more friendly. I mean, everyone's battling it out. I mean, you're zealously advocating for your clients, but I can't tell you the number of counsel for the other side who battled it out, 2013, 2016, 2018, and at the time I thought they were the worst, and they frustrated me, and now we're really really good friends. I mean, you had Brent Babcock on earlier, and we've battled it out. I mean, just over good, send Christmas cards to some of these guys that had, thinking that could have happened in 2016 would just be totally out of this world. But, because I think, we're mostly arguing about things that matter and making arguments for the right reasons. I think there's a respectfulness and collegiality in the PTAB bar that, doesn't exist, at least from what I've seen in some of my litigation matters.
I think that's probably fair to say. And what I'm about to say, I know now, is going to come across as self-serving, I suppose. But I think patent attorneys are a different breed. And PTAB attorneys are even maybe a more different breed. We're half science, we're half law. The patent attorneys I know are extremely intelligent and dedicated people, and they really just like doing what they're doing. And even when you disagree with somebody, they make points that you can't easily throw away. Now, I get it. There are at times the flamethrowers that are out there that say things that come across as really BS, but most people in this space are not that way. And for example, over the years, I've become good friends with Scott McEwen. And when I'm pounding my chest and waving the flags for inventors and the importance of patents, he says to me, wait a minute, hold back there for a second. The companies that you're talking about, these inventors, these patent owners going after, are American companies too. They employ American workers, hundreds of thousands of workers. They pay taxes. They contribute to the economy. And it's hard to argue that. I mean, he's right. So both sides have merit. And that's one of the frustrating things I think about this, is because both sides make good points. And sometimes we're talking past each other. Maybe not sometimes. It seems like most of the time both sides are talking past each other because they have a certain reality in their mind. And when they hear the other side making their points, they often think, at least I think it seems this way, they often think that the other side is minimizing their experiences. That leads to a lot of emotion. And when you have emotion, it's very difficult to get anything constructively done.
Yeah, I mean, there's definitely a balance to be had. I don't think anyone contests that there are no bad claims coming out of the office that could use correction, and also that patent owners face a real uphill battle, particularly after institution. I think that the PTAB hasn't functioned exactly how it was meant to, and I think there is a balance, but maybe it's just a artifact of the world today that everyone likes to argue and yell in absolutes, and nuance gets lost. But I said on the panel earlier at the end, I feel like there's there's some compromises that can be made, some discussions that can be made, that it's maybe just trying to be optimistic and sleep at night. But I think there's a way to progress here, and but we just have to get smart people in the room, get over that inclination to push for everything, and see what small changes so we might be able to make that maybe lead to bigger ones, and a system that's fair and gets to what what we want in a patent system.
I'm going to follow up on that here in a minute, but before we get there, I wanted to say that over the last day and a half or so as a part of this program, there were several things that caught my ear, some that maybe even surprised me, and I'm happy to share what those things are. But let me ask you, was there anything that you heard that really piqued your interest or maybe caught you by surprise a little bit?
I was struck by the passion that on both sides of the issues, and thinking about how that plays into the ability to make changes, the ability to get things done. Talked on the legislative panel how as time passes on, the less and less likely that we're going to get solutions from Congress. That's kind of settling in as a realization as well. But just how strongly folks feel about these issues, for the better, or maybe complicating discussions, that really struck me the last couple days.
There certainly is a lot of passion, and there certainly is also a lot of sensitivity as well. And I understand why that is. Patent owners feel like they've gotten the short end of the stick for a while, and I tend to agree with that viewpoint. And given all the sensitivity and given all of the emotion, I think it makes me realize that we have to be very careful about how we say things. Because there was a couple times during the program that something came up and people were saying, are you trying to say that it doesn't matter whether the claims are valid and there should not be a means to reverse them? And it's like, no, that's not what I'm saying. Actually, I'm saying the exact opposite. I've always said that a system has to have an error correction mechanism. The question really is whether or not the PTAB is that right balance to do that particular job. And I'm not sure that it is. And in my viewpoint, I don't think that it is, because I think what we've done is we've allowed the bad patents and the bad actors to thrive in this space without really going after them in a way that I thought we were going to do that. So that's been a little bit frustrating for me. The other thing that's been frustrating is to watch the PTAB at times weave together 5, 6, 7, 8 or more references for an obviousness rejection. Now, this is just me. It's something I've always said. But once you get over 5, it just seems to me like it's an admission that the invention is not obvious. And I understand that's not what the law is. But if you're allowed to just weave everything together, then at some point, nothing is going to be patentable.
Yeah, I mean, I think four. I was going to say 4 references, but 5 or more references. I mean, that just kind of begs of hindsight, personal opinion, and not any.
Right.
Hopefully that.
Right.
But and that came up a couple times through the week, and I mean, maybe just it hasn't been prevalent in the cases I've been involved in, but to the extent that that does raise some questions about the obviousness of the claims. Maybe I'm just unlucky on the patent owner side, and I'm mostly getting the 2 or 3 reference obviousness grounds where it feels like it's a closer call, and that's what I'm aiming for when I'm preparing a petition. Is I'm telling folks, hey, we got to keep searching until we can make a credible. I mean, anticipation's great, of course, but a 2 reference obviousness ground, a 3 reference maybe. But not more than that for the independent claim, or else we're going to face some strong arguments in opposition. So that did jump out to me a couple of times when we were talking about 4 or 5 reference obviousness. That the petitioner should be able to make some hay there.
You would think so, right? And I realize that that's not what the law says. So those listening who disagree with this, you don't have to send me your emails. I know what the law actually says, and there's no limit to the number of references that can be weaved together. I just think it's ridiculous once you get over a certain number to weave these things together and then claim it's obvious. And I also think that maybe is a reason why so many of these cases that go up to the federal circuit from the PTAB do wind up getting affirmed, because it's not legally incorrect to weave 5, 6, 7, 8 references together. It just seems to me to be intellectually dishonest of what we're trying to figure out is whether or not there really is an innovation that somebody who's of ordinary skill in the art would have thought about before the invention. But enough about that. One of the other things that did catch my attention, and it's an issue that has mattered to me for a long time, is this issue about patent trolls. And I've referred to them, or at least started referring to them, as ankle biters. You know, the people who buy a patent that has nothing to do with what it is that somebody is doing, and then they put it in front of that person and say, pay me $50,000 and I'll go away. That's just a bad actor. And it occurred to me during the petitioner panel that we had at the program that when we were listening to the in-house petitioner side people talking, that this is really a 112 issue that you just can't get at or even address with IPR. So maybe we should have a PTAB that doesn't second-guess examiners based on obviousness, but maybe the PTAB should really be looking at this issue to see what is your application cover, what do your claims mean, and are you trying to over-assert it compared to what the claims are that have been granted to you, which is really a 112 issue, I think.
Yeah, I mean, I guess the tough spot is you have infringement divorced from invalidity and claim construction. And I think that's when it becomes the most apparent when you see what the accusation actually is, and you look at the patent that has nothing to do with it. It can't be there. There have to be 112 issues here, but the patent owners, the troll patents, are able to dodge that by in most cases settling long before Markman. And what struck me in the conversations about the ankle biters was trial court judges have the ability to address this, potentially via sanctions. The case doesn't get that far, and maybe it's easier just to have it off your docket. But a judge who's aptly motivated to put a couple folks' feet to the fire on the really egregious stretchings of claims, might go a long way towards curbing some of it, making them think twice about it. To your point, it is somewhat the tail wagging the dog. We're doing things to address trolls, but at the potential expense of the operating companies, and that should be where the big battles are being fought. Shouldn't the system be looking at those more than the small ankle biter cases?
I think that the only group of people that have gotten through the last 15 years unscathed are those ankle biters, and that just frustrates me. They've been unaffected for a variety of reasons, as we have just mentioned, and I guess I understand that when somebody comes up and asks for $50,000 to make their dispute go away, you can't spend $50,000 just for the filing fee, plus whatever the attorneys are going to charge you in order to do the due diligence to get the case filed and prepared and ultimately litigated. I understand. I don't like it, but I understand why operating companies do cave. The problem that I have, however, is that when they do cave like that, and they do give in to these people, it just begets getting more of those nuisance actions brought against them.
Yeah, I mean, there are a few companies who will fight to the end, and I give them credit for doing that. But and for most companies, they want to focus on making great products, developing the next innovation, and these patent cases are, one, expensive and a drain on that, and two, a distraction. And so the unfortunate reality, just the asymmetric warfare that is, U.S. litigation and U.S. discovery. In theory, it sounds great to battle all these, but for most companies, it's just tax on doing business, and the tax is smaller if you write the check for 20, 30, 50 grand.
Okay, so now let's pivot a little bit. One of the reasons why we specifically wanted to have this conversation was because you had some ideas about how to make the PTAB, or maybe it's make IPR processes better, more efficient, fairer perhaps. So I want to get into those, and I'm going to kind of put you on the spot here, if you don't mind. I'm going to ask you to pick the top one. So let's say you are director for the day, and you can do whatever it is that you want to do. What is your top suggestion to improve the PTAB or to improve IPR, generally speaking?
If I get an act of Congress, I would be able to get my favorite one through. Is one of the things you hear from time to time is the post-grant review. I think the Patent Office is frustrated that more PGRs haven't been filed, and I think we want to be more like Europe, and we want to have these opposition proceedings to get our early challenges in. And I think there's some sense in that. I think the PGR statute is really scary for petitioners, and I think it's probably a bit broken. The downside of pursuing a PGR is potentially pretty great. The estoppel is worded the same as the IPR estoppel. You're estopped after losing a final written decision from raising any ground you raised or reasonably could have raised in the PGR or IPR. But because the grounds you can raise in a PGR are so much broader, your 101, your 112s, as well as your 102, 103s, if you lose a final written decision in a PGR, you've essentially transformed yourself into a punching bag. You're left with almost no defenses to an infringement allegation, and so companies are really hesitant to go down the PGR route. I think a tweak to the PGR estoppel statute could benefit and entice some more folks to go down that route. As I said, the estoppel is you're prevented from pursuing any ground you raised or reasonably could have raised. If you tweak the estoppel to only be stopped from pursuing the grounds you actually raised at the PTAB in a future litigation, I think it would be less scary. Maybe a claim has a 101 issue or a 112 issue that you think is a knockout. You might be more willing to bring that challenge at the PTAB if you're not going to be foreclosed from arguing prior art in a litigation down the line. Prior art, if you just sit tight, you may find prior art that you don't have in hand now, 2-3 years from now. Maybe AI searching gets better and you're going to discover more prior art. So to just go for broke in the first 9 months of a patent is a tough path for a petitioner, especially one who hasn't been sued yet. If you're not entirely sure you're in the crosshairs yet. Now you've made a PGR petition, so you've at least shown that you're concerned about the patent. You're certainly in the crosshairs, at least from a revenge point of view. And then if you lose in the final written decision, now you're just sitting there asking to get sued. So I think a tweak to the PGR estoppel statute could make those at least a more attractive option. If not something closer to what's done in Europe.
I think what wound up happening, if I have my recollection correct here, is that they printed the bill and put it on the desk for voting in Congress, and that was not the last version of the bill that everyone had agreed on. So they went backwards and printed an older version that had a different estoppel provision with respect to PGR. And then they voted on that. And then once they voted on that, whatever it is that they voted on becomes the law. And it was not easy to make a mistake. Now, there are provisions for making adjustments that are to clerical errors. The problem here is yes, this was a clerical error in one respect, but it was substantive. The change was going to need to be substantive, and that type of fix is a very different type of fix, and it just never wound up being addressed, unfortunately, I guess, or fortunately, maybe, depending upon your point of view. You raise an interesting point here, but I do think you would need to be patent czar or maybe patent king in order to pull this one off, because an act of Congress is necessary.
I think so. I mean, maybe we can't get enough people on board. Because on the basis of it just being broken, it would have a substantive effect. There would be more challenges. So the patent owner-friendly lobbies would probably take issue with it. I think it's unlikely to happen based on that, but I think it's kind of clear what was meant to be.
Mm-hmm. I actually think both parties on both sides would object to that for different reasons, obviously. But then if they're both objecting, that probably makes it a good and reasonable fix.
A negotiation when no one's completely happy. But yeah, it's probably on the wish list and may stay. That's one that I would really enjoy seeing, just from wanting the PTAB to function how I feel like in my gut it's supposed to.
You also had something on your list about IPR estoppel.
Yeah, and that one, I think it's a little more of a quality of life than a substantive change. I think IPR estoppel attaches at the wrong time, and IPR estoppel in 315 attaches at a final written decision. Over the last 5-6 years, the Fintiv and Sotera lines of cases have come down saying, really estoppel should apply sooner. You shouldn't be able to file a petition, get it instituted, get a crack at validity in the trial court, and then get another one from the PTAB after. And then to counter that, the petitioners came up with the Sotera stipulation where you said, okay, well, we'll in exchange for institution, we'll agree to the 315 estoppel at institution. And there's a bunch of briefing back and forth and emails to the board. And I think just by changing when the estoppel attaches in Section 315, you would shortcut Fintiv and Sotera, and probably, I think in my gut again, get the system where it was meant to be. Yeah, petitioners shouldn't get two cracks at it. But you shouldn't have to have a lot of back and forth and extra briefing and stipulations. Just make the estoppel attach at the institution decision, and you streamline the process quite a bit.
Would there be any implication for reexamination with this particular suggestion that you're making?
So 315 does apply to patent office proceedings, so the petitioner would be prevented from maintaining patent office proceeding. But yeah, if your trial gets instituted, you wouldn't be able to petition for another re-exam on those claims. So I think that's one where petitioners would be happy. They want to be if they want to be in front of the PTAB, which you assume they would, based on their having filed a petition. So they agree to what they have to agree to. Now they're forced to agree to that Sotera stipulation. Just put it in the statute, and I think it simplifies things.
And just to make sure I understand what you're saying, if the case was instituted, then you'd have estoppel. But if the case was denied for whatever the reason may be, then there would be no estoppel. Is that what you're saying?
Petitioners agreeing if trial is instituted. I'm not going to argue 102, 103. In the old days, based on patents or printed publications, now the office is pushing petitioners to give up all of 102, 103 in exchange for institution. But if you just make the 315 estoppel apply at trial institution, then it just gets rid of all the Fintiv line of cases, the Soteras. It just implements those with just a couple word changes in the statute.
So you also have something on your list that I've been championing for a very long time, which is quiet title. But when I look at the way that you describe what it is that you're thinking about, I'm not sure exactly it's precisely what I'm thinking about. So can you fill us in on what your ideas are there?
So we talked about this was that a year ago? We were throwing out ideas for quiet title, and I've been trying to think of how. So, of course, settled expectations is our best analog for it right now. 6 patents are 6 years or older since their issuance are difficult to challenge at the PTAB. The patent office will say it's not a hard and fast rule, but it's working towards that limit. I'm very sympathetic to the idea of a quiet title. That hard and fast 6-year rule, it doesn't feel quite right, because what about someone who's sued for infringement who really wasn't aware of this patent, didn't see it coming? The patent office, the PTAB, says there are arguments you can make towards that, but I don't know that those are really effective for challenging patents that you get sued on that you just really didn't have great notice of. They weren't on your radar. I've been trying to think of mechanisms for addressing the notice issue while also being thoughtful towards the patent owners' quiet title desires, as you put it over the years. One thought was, could you have some sort of registry where people who are patent owners who are considering asserting patents, could they put this on make a form submission to a patent office website and say, here are patents I'm considering asserting in the coming years. And now, based on that list, the world's on notice that these patents are possibly going to be asserted. And you, as a matter of PTAB policy, have 1 year to challenge those patents. And at the end of that year, those patents that have been on the registry are IPR proofed. You can't challenge them because you had your chance. They've sat there for a year, and now the patent owner is entitled to some solace that they're not gonna, as soon as they file an infringement case, gonna have to go back and battle at the PTAB.
I think that would make some sense, and I'm not ready to sign on to it or endorse it because I'd like to see a little bit more about it. But generally speaking, I think that is something that could potentially work. But I'd like to acknowledge that I think the Patent Office would have an issue with you saying that the 6-year time frame for settled expectations is hard and fast. It's a hardline rule. I think they would disagree with that. But then I wonder about this. During the program and already here, we've talked about the situation where you have a patent being acquired that relates to X and then being asserted as it relates to Y. And I wonder whether or not, even if people knew that that patent existed, whether or not they would have any reason to believe that they should be challenging it. And I think that's the big concern for petitioners, is you see a lot of these things being over-asserted or asserted in ways that don't really pay true homage to what is covered in the patent itself. And that is quite a bit frustrating for petitioners, I know. But then I wonder whether or not those types of patents ever wind up finding their way to the PTAB to begin with. I mean, if the ankle biter is only asking for $50,000, is that patent going to be subject to an IPR? I think the answer is certainly no. So maybe that category of cases where you have somebody who's way over asserting what the patent covers just never winds up at the PTAB.
Yeah, I mean, I think those cases where, and everyone has their thoughts and definition of what a troll is. I typically think of it not whether it's a practicing entity or a non-practicing entity, but it's someone who takes claims and then gets out their tools and stretches those claims to the extreme to try to capture activities that really isn't the intention or what that patent should be covering. So yeah, I mean, I guess there could be some still gaming of the system by putting a patent on that list and going after and getting people who are still unsuspecting. But the other thought I had was a second column on the here's the patents I might sue on registry, and have an industry column. I'm thinking about asserting this patent in this industry to give a little further hint about who's at risk here and who should be considering filing their PTAB petitions. And the comment came up earlier today. On some products there are thousands of patents that may be actually of issue, and then when you take into account folks who are going to stretch claims indiscriminately, maybe tens of thousands for some. The notice issue for accused infringers comes into mind when we start talking about putting a hard and fast timeline on what is settled expectations. It's just tough to say your time's up when I never thought of that patent, never heard of it before, and now I'm left without one of the ways of recourse that Congress put into the system for me.
I get that. That makes sense to me. I sympathize with those who get attacked by people who just come up out of nowhere. I mean, that's just no way to run a system. Attack by surprise is something that we should be able to deal with, I would think.
It's difficult, and there are a lot of those suits out there. You look in Docket Navigator each day, and what's the right way to deal with those? But then again, how do you deal with those while not letting those wag the dog for the legitimate disputes between competitors, which ideal world is where our efforts and resources go.
The thing that is so particularly frustrating to me about this is that if we can't solve for this type of situation, what hope do we really have to try and solve for those situations where there is an honest difference of opinion? And, during the PTAB program, I asked the in-house panel for their perspective on this, and I asked them how many of the patents that they see and the inquiries that are made are just really garbage, where the patent is garbage and or they clearly don't do anything that relates to what the patent is all about. And the answer that we got was somewhere between 50 and 60% of what they see qualifies as that. Now, if we could eliminate that and focus on that and come together to deal with that and have some kind of system in place that would give some relief there, then now maybe we can make a difference. But if we can't solve for that, I mean, it's just, I don't know what to do. And I just want to throw my hands up in the air and say, oh my goodness.
My gut is that that's the right path to that is through the trial courts. These are bad faith litigations, and there's mechanisms in the system for dealing with those. The clever hack is to kill the litigation before it gets to the point where the court can credibly address that. But it feels like that's the right spot for dealing with that issue. And then downstream, we enjoy the benefits of getting to do the patent arguing on what matters.
I agree with that, and I think there is a lot more that district courts could do, and this just always draws me back to law school. When you first in civil procedure are learning about Rule 11, you read the rule and you say, oh, this is a great rule, it's sensible. There's something that can be done in this situation where there are abuses. And then as soon as you learn about it, you realize that it never gets used. And that's just a hard pill for me to swallow, because I just don't understand why you tolerate this kind of frivolous behavior. Because the one thing that we know for sure is if there are no consequences for this kind of frivolous behavior, then there will be more of that frivolous behavior. If you want to get rid of this frivolous behavior, you have to call it out, and there has to be consequences for it. And just to cascade for a moment here, this is also what has always upset me about Rule 36 in the Federal Circuit. Now, I understand when I've written about this in the past, I've heard from former clerks, and they're like, a lot of those cases where there's Rule 36, they're just not good cases. Maybe they're frivolous appeals, they're poor appeals. And if we had to write decisions about that, or the judges that they worked for had to write decisions about that, there would be sanctions. And well, then sanction them. If you don't want frivolous appeals, you have to stop the frivolous appeals. If you don't want frivolous actions, you have to stop the frivolous actions. There needs to be consequences, period, the end, in my opinion.
There's a temptation when you can buy a patent and then go sue 20 people and pick up 20 grand a pop for very, very little work, and the district court filing fees are so small, and the risk is minimal if at all. There's going to be people who are going to take advantage of that, and until someone or something stops it. But yeah, it is a shame how much that skews our patent law to deal with these bad actors, and there should be a path towards getting us back onto the merits.
It just sucks that the people who are willing to do this, the people who have really no morals whatsoever, they're the ones who wind up succeeding the most, or at least collecting the most amount of money. Now, if you're playing a board game like Monopoly or something like that, collecting the most amount of money is the object of the game. But when you're looking at life, it just really sucks that these are the people who are succeeding on such a high level, at least a financially high level, with no consequences whatsoever, as far as I can tell.
Yeah, no, they basically have generated a money printing machine for themselves. But it takes some solace that there are so many of us that have their eye on something bigger. Like we're part of a system that's promoting inventions, developments, the function of great companies. And so we're not all racing to the bottom to do that. It's a select few who get some benefits from it, but there are folks like you and others who are really thinking about how to make the system work optimally, and along the way we'll head these guys off. But
I agree. And maybe the real story here is that despite the amount of money that can be made if you're willing to be a real jerk without any morals, the overwhelming number of people in our industry just don't do that. I think it's the 99% of people in our industry are trying to do things right. We may disagree about this or about that, but most people overwhelmingly are in favor of a strong innovation system and want to have a patent system. And the viewpoint of what that means is often just clouded, and that's probably not the right way to say it, but is often influenced by what it is that you see actually happening on the ground, the facts you have to live with, and the bad actors on both sides that you have to deal with. And that takes up too much of a proportion. So maybe it's not 99%, but it is clearly the overwhelming number of people in our industry, I think, are trying to do things the right way.
Yeah, there's more to life than money, and I like to think what we're doing, regardless of exactly who the client is that day. There's a noble aspect to it, and I always think it's so cool. You think back to the Constitution and Article 1, Section 8, that this is something that was on the minds of the founding fathers 250 years ago, 250 plus years ago, and so we have a job to do here that's important, and we're not doing this for nothing and for no reason, and we're not just looking to make a bunch of money. Let's do what we're doing, good stuff for the right reasons, and keep pushing the ball forward.
So this has been a really great conversation. I really appreciate you being here to do this. But before we run out of time, I'm going to make a little bit, maybe it winds up being a little bit of a hard pivot here, because there's one thing that I want to ask you about that was also on the list that you provided to me with your ideas of how to make this system better. And I'm not sure I really understand what it is that you mean, but I'd like to hear what your thoughts are on it. You mentioned summary institutions. What can you tell us about that?
I think back in the day when the PTAB opened for business, I don't know that folks really expected the fulsome institution decisions like we've seen for the last 13, 14 years. I'm not sure folks thought that was how the system was going to run. I think folks expected something more akin to maybe Acting Director Stewart's 2-pagers, 3-pagers, or maybe just a form thumbs up, thumbs down. Was what was expected. And I think when we started getting 40-page institution decisions right out of the gate, that was surprising. And I think it's had some downstream effects that are suboptimal. I think it's great for the parties to have the panel's insight up front about why trial was instituted, what arguments they thought was strong, and what arguments they thought were weaker. And that informs the play out, how the trial plays out. But I think having at least one of the judges really dive into the weeds and make a decision on, in most cases, all the important points that the patent owner raised in their preliminary response, set up a bit of a confirmation bias that in a lot of cases hijacked the rest of the trial. If you as a patent owner put all your best arguments in a preliminary response and they all get shot down, one, you're in a tough spot, because what are you going to come back with over the next year in the trial beyond having your experts say nuh-uh, and on some level potentially banging your head against the wall, pushing a rock uphill, whichever euphemism you prefer. I don't know that full evaluation, just based on the preliminary papers, one, made a lot of sense, and two, was great for the system. I think divorcing the institution decisions from the final written decisions will bode well for patent owners. I think that confirmation bias that came from the really detailed institution decisions led to the 80% kill rate of instituted claims. It's hard to change the mind of someone who has sat and written 40, 50 pages detailing why these patent claims are probably no good. It's hard to change their mind. And so I think patent owners under the new system with shorter or no opinions by a different party that's making the final written decision will result in better outcomes for patent owners in final written decisions. And then one other item that I thought of the last couple nights when thinking about our talk here today is engagement of the panel during the trial. What has seemed to happen, and it's a little sensitive, and I know the patent office will dispute it, but there's one judge who kind of takes the lead on institution decisions, at least on drafting it, and they're the ones who really get into the weeds, and they're the kind of the experts on the matter. They've made up their mind, at least preliminarily, at the institution decision. And there's a sense as you go through the rest of the trial, particularly at oral argument, that they're the most engaged of the the three judges. And most of the questions in an oral hearing will come from that same judge who wrote the institution decision. Final written decision will typically be written by that same judge. And I at some point, as a patent owner, you feel like you're arguing to a panel of one rather than a panel of three, and that's a bit outside of how I think the system was meant to run. I think if you have the trial is really a fresh look by a new panel, by new people who didn't make the institution decisions, I think you're more likely to have all of the judges on the case dive in and be more prepared at oral argument, ask questions, and participate in the decision making more so than where there's a feeling that the matter is already decided at institution. And another reason they might be able to dive into the weeds a bit more is the workload of drafting those 50-page institution decisions would be taken off the table. So judges, in theory, would have individually more time to do prep for hearings. Have that hearing be more of a discussion between the two counsel representatives and the three judges, where if you look at oral hearings, a lot of them are two attorneys and a judge doing most of the talking.
I agree that I did not expect these 40 or 50-page institution decisions. I mean, these judges put so much work into that. It's going to be very difficult to put that aside and start over. And it just seems like that wasn't the whole idea of what we were supposed to be doing. I mean, maybe it was beyond going and looking for just the low-hanging fruit. That it might not be the best way to say it, but I didn't think we were going to get into this second guessing of examiners. And if you've already put in 40 or 50 pages before you've taken any testimony, before you've had any depositions, before there's been any discovery, and I understand the discovery is quite limited, but before you get into the case, if you have 40 or 50 pages down, it would take a very special person to just throw that away and start all over. What I've thought we should do for a very long time on the institution stage is to have a small group of people who are assigned to look at these and decide whether or not to institute all of them. And I think you don't need any more than one single person per institution request, per filing, to look at this and say, is there smoke there? If there's smoke there, then maybe we go forward with it. And we spend our resources looking at the cases where there's maybe the biggest potential mistakes that have been made, and maybe it wasn't a mistake, maybe it's late arriving prior art, whatever the case may be. Go after those cases that are the worst ones and do something there. Institute those cases that are begging for a second look and then kick it over to the panel to do the work from there. That's what I would like to have seen. And that's why I really like the director taking over the whole institution decision, not just discretionary denials, but the entirety of the institution decision. I think it's the right move.
I think, at least as the Supreme Court said, throttling institution decisions is legitimate executive action. Coelho said that 314A gives the PTAB broad discretion. So, but having the filtering done on the merits feels so much better than the filtering being done on six years since the patent issued, or the suit was filed in the ITC or in Texas. The timing of that. If the patent office wants to set that number, make the cutoff based on the merits of the challenges. I know it's difficult in resources. Make that maybe difficult, if not impossible. But that's how the system should work. And to avoid game playing arbitrary rules, easier said than done, of course.
So I'm going to take issue with that, but not what you just proposed, really. What I want to take issue with is the fact that resources should be an issue or a problem at any point in this entire process. The entire point of this whole PTAB experiment was to come up with a more streamlined, more efficient way to handle cases, take them out of the district courts, but get a good, proper adjudication for them with respect to validity or invalidity, depending upon how you want to look at it. Resources become an issue with the PTAB taking all comers. Come one, come all. We've got a decision for you. It doesn't matter whether we've looked at this patent previously. Doesn't matter whether it's been challenged in court somewhere. Doesn't even matter whether the Federal Circuit has seen it. Doesn't matter whether it's been licensed for how many years. That's where the resource problems come up, when you're doing, redoing, constantly redoing the work that the office has already done. I would rather take a look at the patents that are the worst patents, whatever that means, whatever the bad patents are that need attention again, let's take a look at them. If that's 20 a month, if that's 30 a month, if it's 40 a month, whatever the number is, but we got to get out of the business of the patent office redoing, re-reviewing the work just because somebody filed a petition. That doesn't make any sense to me from an administration of justice standpoint. And one final thought on that point, if you do allow for the re-review, constantly re-looking at patents, taking all comers, regardless of whether this thing has already been considered by the PTAB, that's what causes people, me included, to wonder whether or not patents are really property, because there is no such thing as quiet title if they can just constantly be challenged over and over again by just the next new challenger. We would never tolerate that in a real property regime, and I don't understand why we tolerate that in an intellectual property regime, but that's just my issue. Although now with the Patent Office raising settled expectations, I suppose that is become an issue for the system as well, and I think that's a good positive development. But the one thing I do worry about is a snapback, and when a snapback happens, it's usually very quick and it's very severe. And I think that there's a risk that people will look at what's going on here, becoming much more pro-patent owner, and then the consequences longer term are going to be, whatever longer term means, are going to be that it's going to snap back the other direction, and maybe even more so than it ever was. And I think I heard somebody, and it may have even been you, Matt, who said during the PTAB program that we just finished here with that over the last month, there have been only 25 petitions, and there have only been 4 or 5 that were actually instituted. Now, if those are the numbers, I think that's going to give Congress, maybe some others, some pause and say, oh my goodness, have we gone too far? Now, I don't think we've gone too far, but at the same time, I think we all need to be cognizant on the patent owner side of this, that there will be that perception. And I do worry about that a little bit.
Yeah, that was me who made the comment, and that was just the last week's institution. The PTAB's been putting out a summary document once a week saying this list of cases is denied. This case, there were 25 denied for procedural reasons, a set of maybe 12 that they said passed the discretionary denial and the director was going to consider for the merits, and then 4 were instituted. So yeah, it was 25 procedural denials and 4 institutions. So I think we felt a patent owner challenger pendulum that would swing back and forth by administration or developments in the law. And we've seen now that folks are willing to just walk into the circle and grab the pendulum and take it all the way to one side to match their view of what the policy should be. But definitely fear that, someone else could come and grab it and wrestle it the other direction. I think I mentioned earlier that ways that could happen, you could have summary institution decisions the other way, and they're not going to consider the discretionary factors the same way, and they're going to do just a real cursory look at the merits. Is it prior art? Did the petitioner just wholly ignore a limitation? If not, trials instituted, and the rate goes back to 2012, 2013, 85% institution rates. So we've seen the pendulum the other direction. Some sort of balance, I think is a lot healthier than predictability and maybe the damage to the necks of practitioners from the whiplash of going back and forth and the rapid changes in this forum that we've seen most recently. But it's a constantly changing forum, which has been fun. But we may be in for a wilder ride than we're used to or comfortable with.
Yeah, that is probably the case. But thanks, Matt. We're going to have to leave it there. But I really appreciate you coming and having this conversation with us. And I appreciate you being a part of the PTAB program once again this year. Hopefully all of this will plant ideas in the minds of decision makers and we'll get to a better PTAB.
Thanks for having me, Gene. This was a lot of fun to get in the weeds and do the PTAB nerd thing with you. And thanks for everything you do, and look forward to doing it again soon.
Thank you for listening to IP Watchdog Unleashed. We will be back next week, and we hope you will join us again. In the meantime, please be sure to visit IPWatchdog.com to read all the latest news and information about what is happening in the intellectual property world. And also be sure to subscribe to our free daily email newsletter.